Madam Speaker. What is the price of a political vendetta? Well, if you're the Minister of Crown and Indigenous Relations and you're trying to shut down the survivors of St. Anne's Residential School, the cost is $2.3 million and counting that this government has been willing to spend to fight survivors of some of the most horrific child sexual abuse, torture, child rape that's ever been perpetrated in the country of Canada. So what is the issue here that this government is trying to suppress? Well, it was the decision by the Justice Department of Canada to take 10,000 pages of evidence, the names of 180 perpetrators, that they were legally obligated to turn over to the hearings for the St. Anne survivors. And instead of presenting that evidence, present what is a lie in a legal term, a false evidence narrative, which was their obligation to present what documents there were to say there was no history of sexual and physical crimes at St. Anne's, but oh, there were so many. Bishop Jules Legérière is named in the list, Bishop Henri Ballot, Father Langlois, Father Arthur Lavoie, who has a persons of interest report of over 2,000 pages. That was suppressed. So what was the effect of that? Well, cases were thrown out. And I would never have stood up in this House and spoken on a case before hearings, except this was brought to me in 2013, almost 10 years into the process, where Edmund Matatawaban came to me and he said, our people who suffered so much are having their cases thrown out. They're being told they're not believable. Justice Department lawyers are lying in the hearings because the Justice Department has these documents. And I thought at the time, as a member of Parliament, if I wrote and said, how is it possible in a legal process that you could suppress evidence, that this would be handled? Well, they were forced to turn over documents, Madam Speaker, but then the question is, what about justice in the cases? So I wrote to the Oversight Committee of the Independent Assessment Process, asking what happens when the government fails in its duty. Nobody dealt with that. I wrote to the adjudicators, what happens when people are denied their most basic legal rights? And nobody dealt with that. And what happened was two cases came forward, Madam Speaker, and this is where the $2.3 million has been spent. One case, H15019, a victim of horrific child rape, who government lawyers said he wasn't believable, that they couldn't even prove that the perpetrator was in the institution at the time, when they had a massive file on this person. That person, that predator, had been in that school for 40 years, and the Justice Department knew it, and they had that case thrown out. And so when this person used their basic legal rights to go back and try and reopen that case, the government said they could not be done. And so I want to read to you when we had Phil Fontaine rose on this issue at the AF. He said that Canada had a legal obligation because of, under the procedural fairness is a fundamental implied in the Indian Residential School Settlement Agreement and the IEP. They were designed to be fair, reasonable, and in the best interests of the claimants. This is what he presented in his affidavit. I always expected the IEP would respect First Nation and individual rights to a process at least as fair as any other hearing before a court or similar process. And he said he would not have signed the agreement, this was his affidavit, if he had known that the basic principle of procedural fairness was not respected. And the government lawyers ridiculed Fontaine's position, stating that they should not give any evidentiary weight to this affidavit of Phil Fontaine, who signed this agreement, the Indian Residential School Settlement Agreement, and said that his paragraphs are largely speculative in hindsight. At no assistance is to receive theoretical views of subjective intent. It wasn't intent, subjective.
Unfortunately, the time is up. The honourable member will have another minute. The honourable parliamentary secretary to the Minister of Crown and Indigenous Relations.
Thank you, Madam Speaker. We are committed to justice for all Indian residential school survivors. As the member well knows, our government has provided all the documents to the courts, those that have been asked for, when it comes to the St. Anne's Residential School. We're also working with those claims that were affected by the previous government's actions to settle those in a fair and equitable way. It's important to note that more than 95% of all claimants from St. Anne's have received compensation, much higher than the national average for residential school claims. As the supervising court has made clear, and I quote, "The evidence shows Canada has kept its promise and continues to keep its promise." While now most claims have been resolved, Madam Speaker, those few remaining do include the most difficult and challenging. And unfortunately, Madam Speaker, that has led to far too many court challenges. As the administrator of the IRSSA, Canada has a duty to defend the integrity of the process and to ensure fairness for all participants. These cases have brought further clarity to the process, ensuring that all survivors are treated equitably and in the spirit of the Indian Residential School Settlement Agreement that was approved more than 12 years ago. The legal fees referenced by the honourable member is an accounting of existing internal legal resources, which were dedicated to ensuring that claimants receive the compensation they deserve and the integrity of the independent process. No outside fees have been incurred in any of the cases brought against Canada. It's also important to note that Canada has never, and our government will never, seek legal costs against any individual claimant. In exceptional circumstances, costs can be sought against lawyers who do not appear to be acting responsibly. Sadly, Madam Speaker, in one of these cases the member refers to, the court has stated that counsel's repeated and deliberate attack on the integrity of the court threatens to interfere with the administration of justice. Baselessly attacking the credibility of the courts and of the independent assessment process that has handled more than 38,000 cases does a great disservice to survivors. Counsel is responsible for the symbolic costs that have been awarded, and they will be donated to a fund that supports former students. Our government has reached negotiated settlements to undo the harm caused by the previous government's unethical legal arguments, such as the so-called administrative split. Our government has reached negotiated settlements to address claims of student-on-student abuse who face too high of a legal bar to be fairly compensated. We have repeatedly shown the willingness and desire to work closely with survivors to help them on their healing journey and to undo the terrible legacy Indian residential schools have left in Canada. As the courts have said, the evidence is clear. Our government has kept and is keeping its promise to residential school survivors. Thank you.
Member for Timmins James Bay.
Well, that's ridiculous. We have that Minister of Indigenous and Crown Relations who spent $2.3 million fighting survivors of child rape. Why? Because her officials went in and suppressed evidence and lied in those hearings. And so when Phil Fontaine brought forward his affidavit on the fundamental legal principle of procedural fairness, he said they never would have signed this Indian Residential School Settlement Agreement if the rights to procedural fairness that were given to survivors who fought in court were also given under the IEP. And we have her officials going all the way to Superior Court to shut down two key cases. They're not difficult cases. They're the cases that will show how much this government has gone to suppress evidence. So yeah, St. Anne survivors, some of them have received compensation. But we have no idea of how much compensation has been denied accurately because the refusal of government to turn over evidence. So I ask my colleagues, what kind of government allows a kangaroo court where people are not denied procedural fairness? This is a question, and Carolyn Bennett has a vendetta against this.
I'm sorry. The honourable member is out of time, and the honourable member does know that he's not to mention an MP or a minister by name in the House of Commons. The honourable parliamentary secretary.
Madam Speaker, I want to acknowledge the passion with which the member opposite conveys his point. I disagree strongly with some of the conclusions that he's drawing. Madam Speaker, I was given him the opportunity quite quietly to advance his point, however passionately, without criticizing me. I would ask that you would accord the same respect to me as he's leaving the House. As we've said, Madam Speaker, in regards to Indian residential school court cases, Canada has not and will not seek costs against survivors. In exceptional circumstances, costs can be awarded by the courts against counsel whose conduct they find questionable and undermine the integrity of the court system. We have repeatedly shown the willingness and desire to work closely with survivors to help them on their healing journey and to undo the terrible legacy of Indian residential schools have left in Canada. And as the member opposite well knows, 95% of those claims in respect to St. Anne's Residential School have now been resolved. Thank you, Madam Speaker.